In his dissenting opinion, Justice Khanna emphatically held that the suppression of the right to move any court for the enforcement of the right under Article 21 upon a proclamation of emergency would not affect the enforcement of the basic right to life and liberty. The Constitution was not the sole repository of the right to life and liberty. ADM Jabalpur goes on even to say so. Then, my lords, if your lordship will just leave that paragraph 525, internal paragraph 525, and your lordship's comment then comes at the bottom of that paragraph. Even in the absence of Article 21, it would not be permissible for the state to deprive a person of his life and liberty without the authority of the law. Your lordships are actually saying that even in the absence of 21, because of whatever legislation or whatever the law that is being propounded, it will not take away your right to come to court to seek remedy. That was the critical decision in dissenting judgment that my Lord Justice Khanna gave. Then, my lords, at page 136, very quickly, at page 419, paragraph 136, your lordships held as follows. The judgments rendered by all the four judges constituting the majority of ADM Jabalpur was seriously flawed. Life and personal liberty are inalienable to human existence. These rights are, as recognized in Keshav and Bharati, primordial rights. They constitute rights under natural law. The human element in the life of the individual is integrally founded on the sanctity of life. Dignity is associated with liberty and freedom. No civilized state can contemplate an encroachment upon life and personal liberty without the authority of law. Neither life nor liberty are bounties conferred by the state, nor does the Constitution create these rights. Neither life nor liberty has existed even before the advent of the Constitution. In recognizing the right, the Constitution does not become the sole repository of the right. It would be preposterous to suggest that a democratic Constitution without a Bill of Rights would have individuals governed by the state without either the existence of the right to live or the means of enforcement of that right. The right to life being inalienable to every individual, it existed prior to the Constitution and continued in force under Article 372 of the Constitution. Justice Khanna was clearly right in holding that the recognition of the right to life and personal liberty under the Constitution does not denude the existence of that right. Apart from it, nor can there be a fatuous assumption that in adopting the Constitution, the people of India surrendered the most precious aspect of human persona, namely life, liberty, and freedom to the state, on whose mercy these rights would depend. Such a construct is contrary to the basic foundation of rule of law, which imposes restraints upon powers vested in the modern state when it deals with liberties of the individual. The power of the court to issue a writ of habeas corpus is a precious and undeniable feature of rule of law. And your lordships can consider various other judgments, and your lordship then finally overruled the majority as far as the habeas corpus case was concerned. Because I'm asking your lordships to consider whether the same perception would apply to interpreting the Constitution. I'm not asking that any part of the Constitution be held void. That would be a very far-fetched argument. But the integrity of the Constitution and the harmony of the Constitution in the sense of how it tries to represent primordial rights, my lords, would lead your lordships, I hope, to actually coming to a conclusion that the word established when it comes to minority rights of education is something that had to be considered liberally to include participatory functioning. Only the de jure regulation may come from the statute because it cannot come in our system from anywhere else. But that the purpose of the statute and the heart of that statute and the background history of that statute, of the act itself, would have to be considered. Well, lords, then this is the fundamental argument that I'm placing before your lordship. But if your lordship would now consider going back to my written submissions, well, lords, there is in what I'm saying is supported by the thesis that Ronald Dworkin places in his book called freedoms law, but it's reproduced here as it first appeared, the moral reading of the Constitution. If your Lordship will see, this is at page 9 of my written submissions. Volume 1B. Volume 1B. Right in the top, my lords, is, my lords, I'm emphasizing this because several of your lordships have in many judgments have indicated how Dworkin can influence decision making in terms of how two conflicting views have to be harmonized and how the judge has to come to a conclusion. If I may just read that little bit here, my lords, in paragraph 1. There is a particular way of reading and enforcing a political constitution, which I call the moral reading. Most contemporary constitutions declare individual rights against the government in a very broad and abstract language, like the First Amendment of the United States Constitution, which provides that the Congress shall make no law abridging the freedom of speech. The moral reading proposes that we all, judges, lawyers, citizens, interpret and apply these abstract clauses on the understanding when they invoke moral principles about political decency and justice. The First Amendment, for example, recognizes a moral principle that it is wrong for government to censor or control what individual citizens say or publish, and incorporates it into American law. So when some novel or controversial constitutional issue arises about whether, for instance, the First Amendment permits laws against pornography, people who form an opinion must decide how an abstract and moral principle is best understood. They must decide whether the true ground of the moral principle that condemns censorship in the form in which this principle has been incorporated into American law extends to the case of pornography. Then, my lords, next paragraph, the moral reading therefore brings political morality into the heart of the constitutional law. But political morality is inherently uncertain, etc., etc. Well, lords, then this article goes on to what are the alternatives to this moral view. I would argue, my lords, that this moral view that Dworkin has suggested is already reflected each time your lordships have said that there is a constitutional morality that we must submit to, initially known by way of constitutional values, but your lordships have now talked about constitutional morality. The political morality that Dworkin talks about is similar to constitutional morality that your lordships have applied. And constitutional morality looks at the constitution as a whole, not in pieces, etc., to arrive at an integrated idea. And I submit, my lords, that an integrated idea of constitutional morality would certainly point your lordships towards coming to a conclusion that minority rights can't suddenly disappear by way of an artificially restricted interpretation of a word like established. Well, that's basically my argument to essentially support what all the other counsel have argued, that this is an additional reason, the moral reading of the Constitution that would give your lordships this conclusion. I'm deeply grateful, my lordship.
Yes, Mr. Parasar.
As I am appearing in Civil Appeal 2316 of 2006, that's 701.7 before your Lordship's board. Your Lordships in this 7-judge combination are being essentially called upon to interpret the word established in Article 30 of the Constitution, and whether the meaning of established as given by Aziz Basha is correct. Well, if I have understood the core purpose of the reference. Well, I'll begin my submissions by borrowing from my Lord the Chief Justice's observation today. Well, how do we read Article 30? Do we read as something which creates a ghetto? Or is it for a larger purpose? Well, my respectful submission, and I'll just flag notes, 2 submissions are there, but just as an opening, I'll flag notes, is that in any country, a minority craves for 2 things, which Article 30 recognizes. And those 2 things are firstly to retain its minority identity. And secondly, while retaining its minority identity, to fully and completely participate in the national life and national mainstream. Because in my respectful submission, Aziz Basha, apart from the specific reasoning, proceeds on the basis that you can do either one or the other. You can't do simultaneously both. So you can be a minority, you stay in your space, but if you become a university and the law requires you to, the parliament to enact something, then you lose your status. You can't be both. If you have provisions in your statute which permit others to be part apart from the community for which it is being established, that may disentitle you. Plus, that's the background. Plus, the second background submission is that you lordships will bear in mind that AMU, plus today we are testing AMU status in 2024. In its present form, it has existed from 1920, 104 years. Even if we exclude the MAO portion. And then if we include that, it's 150 years. Plus, AMU is one of the main factors, if not the main factor, for creation of an educated Muslim middle class in India. It is responsible for it and it continues to nurture it. If your lordships were to come to a conclusion that it's not a minority institution, my respectful submission would be that would gravely damage that role which AMU has played. Plus, with that background, my two submissions I'll just flag and then I'll go into them. Plus, the first submission is that the distinction between establishing an education institution and the device to bring it into legal existence is well recognized in our law, which has been completely ignored by Basha.
Distinction between
Establishing an educational institution and the device to bring it into legal existence is well recognized in our law, which has been completely ignored by Basha. Well, that's my first submission, which I'll seek to develop. Plus, any educational institution, forget a university that your lordships have clearly seen, requires a statute. Any educational institution will necessarily require a legal device. A college, a constituent college may require something else, affiliated college may require something else, a school you will require a registration. Plus, the logic of Basha is, and lordship saw that when Mr. Sibal was arguing, that was shown to the court, that the central legislature established the minority institution because the statute was passed by the central legislature, the imperial legislature. Established, and that's the meaning of established for the purpose of Article 30 of the Constitution. Because my respectful submission is, it conflates, obviously, establishment and incorporation. That it definitely conflates. But what it also conflates is established by and established through. It is established by a minority through the legal device of a statute. And this distinction is actually the fulcrum on which all private universities exist in our present day legal regime. I'll show that. Your lordships will just have volume 3I. I just want to show the distinction between established by and established through. Volume 3I, my lords, will have
volume 3
I for India, my lords. Page 3 of that. Well, this is a UGC regulation It's called UGC Establishment of and Maintenance of Standards in Private Universities Regulation 2003. It begins at page 2, my lords, of volume 3I. I am referring to, my lords, the definition of a private university at page 3, 2.1. Private, my lords have that, all my lords have. Private university means university duly established through a state/central act by a sponsoring body with a society registered under the Societies Registration Act 1860. The law, the statute is the device. The establishing authority is the registered society, in this case, a sponsoring body. Well, that's the fundamental distinction in my respectful submission, which Bhasha misses. A statute can be a legal device, well as the highest form of legal device, undoubtedly. There can be lower forms of legal device. A registration certificate under a Societies Registration Act. That is also issued by a governmental authority. By the logic of Bhasha, that is also established by the government. Now, my lords will have just volume 3H. Just the private university regime is based on a sponsoring body. Normally, my lord, it's a business house or it could be a charitable organization which establishes a registered society. They prepare a plan, they put it to the government of the day. The government either enacts an act bringing that university into existence, separate act, or there are states which have a regular one act and you add it as a schedule. So as you come along, you add one university after another as a schedule. Now, in that respect, my lords will have volume 3H.
What about 3.1?
My lords. That's right, my lords.
Shall be established by a separate state act.
That's-
Here, the preposition used is by,
That's right.
whereas in the definition it is through.
Plus that,
What is the effect?
well, the point really is that when established, your lordships are right, it uses by. But I'm trying to emphasize the larger principle that the legal instrument is only a device. Well, obviously, if Bhasha is right, let's test the proposition. Under Article 30, we are interpreting the word established. Every establishment will be by some legal action. Minorities can never establish anything, forget a university. Because it will be even if a college is there, it will be a registered society. The registration will be issued by a authority, established by that central government authority, registrar of societies. Instead of parliament, this is imperial. The finding is, it's the imperial legislature. Instead of that, will be established by registrar of societies.
No, but don't you think that
That's exactly, I'm so grateful to my lords. I'm just coming to that. Because in fact, the private university regime also has minority institutions within it. And my lords, 5 of those institutions are relied on by learned solicitors in his written submission. I'll refer to them. And all of them, in fact, support our point. So, my lords, with that, just come for a moment the UP Act. And that is in volume 3H. Kindly have volume 3H. Page 231 is where it begins. Kindly have page 234. 3H.
the H? 234.
At 236, kindly have the definition of sponsoring body, AA. A sponsoring body in relation to a university established under this act means a society registered under the Societies Act or any public trust registered under the Indian Trust Act. Very similar, AMU was effectively run by a registered society, and Mr. Khurshid pointed out. Now, of course, there was those societies subsumed. Now it continues to exist separately, but it is established by the society through the device of the act.
Which is the provision you're referring to?
It's 2AA.
AA, yes.
At page 236. A sponsoring body in relation to a university established under this act. And my lords, bill has section 8. which is at 242. But I am only arguing for the broad principle. I'm not, your lordships will have 8. On the commencement of this act, the existing universities enumerated in Schedule 1 shall stand incorporated under this act. So my lords, you can have something existing. A legal device incorporates it. Now just have the schedule, my lords, at 261. Plus 261, there's a schedule. Above the schedule, it says 63. Notwithstanding anything contained in this act, the university established by a religious or linguistic minority of the state of UP shall continue to have the privileges as guaranteed under Article 30. Plus, this provision, in my respectful submission, is meaningless if Basha stands. Because Basha says the minute a legislation intervenes, you lose your status. So, my lords, this provision obviously cannot, just like the High Court in the impugned judgment here has said, a parliamentary amendment cannot set aside the basis of Pasha, which is interpreting established under Article 30. Neither can this provision. Now, my lords, we'll just have the first, the Integral University Act. Well, these are examples which the learned solicitor only has given. I'll just come to his written submission. The Integral University Act, it's a minority institution. Serial number 5, Tirthankar Mahavir is a Jain university, also a minority institution. And my lords, over the page at serial number 27, Era University, Lucknow. That is also a minority institution. So the correcting means Era.
What is it?
Era.
Tera, is it?
Era University, Lucknow. Now, my lords, will have the learned solicitor's written submission, volume 2B, page 51. Para 85.
Volume 2.
B for Bombay.
Page
51, my lords, para 85. My lords have that. Para 85. An analysis of legislations establishing other minority universities makes it clear that where the intention was to establish a minority institution, the legislature had included specific provisions in the Establishing Act itself to give the university a character of minority institution. Well, the first example is Sam Higginbotham University of Agriculture, UP. It says, at the bottom, that established and administered by the Ecumenical Minority Christian Society, namely the Sam Higginbotham. Well, my respectful submission is,
51.
this is exactly what the amendment in 81 sought to do in the case of AMU. Plus, the 81 amendment which you lordships read yesterday, the definition of university that was established by the Muslim community, the 81 amendment is exactly this.
But his argument is not that. His argument is at the stage of establishment itself.
But that makes no difference for the reason. I quite see what the question is.
That's not his argument.
Well, but that makes no difference.
Don't-
No, I'm not putting an argument in.
Argument as it is.
No, so my lords, established and administered by the ecumenical minority. The proposition I'm placing for my lord's consideration is this. It makes no difference how the parliament or a legislature describes in the statute as to the formation.
There may be a flaw. Logically, there is a flaw. The flaw is because Article 30 uses the word establish and administration.
Correct.
So you can't by a legislature, even if it is not established, create it. Because then there'll be conflict between the legislature and, in fact, you're countering your own.
No, my lord, I'm making the same. If I've understood my lord
I'm
Justice
saying
Khanna's
no
question.
argument now.
No, if I've understood my lord Justice Khanna's question,
Yes.
my lord,
First, you raise the point that the statute cannot take away my right, which is under the constitution, which is the right given to under the constitution is to establish a minority university or an institution. The statute cannot take away that right. But now you're arguing to the contrary where the statute itself provides for it.
Well, I am saying the statutory amendment, be it in the case of AMU or be it in the case of this university, makes no difference till the time the authority in Bhasha stands, which is that the minute you legislate, you lose the status. So these universities all have to go too. It makes no difference that they describe it. That's the point I'm making. In support of these universities, the learned solicitor is saying that, listen, they say that it is established by the minority, but that's not the test in Bhasha. Bhasha says the minute a legislature intervenes, out you go. So everything goes. I swim and sink with the examples the learned solicitor has given to support his case and against me. So the point I'm making.
So according to what the 1981 Act did was
Yes.
recognize this dichotomy. The 1981 Act recognized that the establishment of the educational institution was by the Muslim minority. The legal form which was given to it of incorporation was brought about by the 1920 Act.
So all I'm saying is that explanation really.
And by essentially what the 1981 Act has done is to recognize that as a matter of fact, the establishment was by the Muslim minority, though as a matter of fact, the form of giving it a legal device in the form of an incorporation was brought about by a statute.
That's correct. But the problems still remain, and that's why the High Court has struck it down. Your Lordships will have page 54. What's the basis on which the High Court strikes down that first university definition? Only on the basis that Bhasha means under the Constitution, established Article 30, established is equal to incorporation. Since you have a statute, therefore in the statute, what the Parliament says is irrelevant, therefore it has to go.
So to the extent that Bhasha equated establishment with incorporation,
Yes.
it was open to Parliament to adopt a varied approach by distinguishing the constitutional facet of establishment
Yes.
from the legal device of giving that establishment a legal recognition.
And that could have possibly been done only through a constitutional amendment. That's the short. So what I'm saying,
A legislative amendment.
constitutional amendment. You would have had to amend Article 30 itself because you are changing the interpretation of 30 as interpreted by Bhasha. So the only thing the Parliament could have done is amend Article 30 itself, which it didn't do, and therefore it has been struck down here by the High Court. That's why your Lordships are reconsidering judicially now whether Bhasha is correct. That's the short point for your Lordships. So my submission is this: if Bhasha,
We have understood.
yes, so that's the first submission. So if Bhasha stands, then if there cannot be a minority university in this country, forget VMU, including the examples the learned solicitor has given. All of them will go. They have to go. If Bhasha stands, all of them have to go. I will go, but so will they. Because the second submission as a subpart of that is, because Article 30 interpretation cannot be hinged on the changing regulatory landscape of educational universities or institutions. Well, I'll just give an example. The East India, before there was no Companies Act. As you Lordship know, the East India Act, a company was established under a specific charter. Until 1844, when the UK Companies Act came for the first time, it was either through a separate act or through a specific charter of the Crown. Today, the position everywhere is that the Parliament can form a company, and the Parliament has enacted a Companies Act in which you can register. There are two simultaneous mechanisms. Something similar is happening on the university side also. Not exactly, but somewhat similar. Plus, these things keep on changing. UGC Act tomorrow can change, my lord. Your Lordship, my Lord Justice Suryakant pointed out, is that a problem? Today, of course, it's a problem. The way it's structured, it is a problem. But if tomorrow it says that you don't need a law for a university, Article 30 cannot be hinged on a changing regulatory landscape. That's what Bhasha has done by saying the minute it's an act to go out. It has to have an independent meaning, irrespective of how the law below the Constitution is changing. That's the second error which Basha makes.
Yes.
Plus, then my other submission is something which was really not submission, but a question which arose from the bench. I'll just try to answer it in very short. Well, like Mr. Sibbal argued, and this is without prejudice to his argument, that once I have established, Basha knocks me out on establishment, then it's under the Article 30, it's my right to administer. If the parliament intervenes through a law, I can say that's violating my right. To administer is my right the minute I'm shown to have established under Article 30.
That may not be fully correct because even if a minority institution establishes it, it may not visualize the right to administer will be retained by the minority community.
Well, I agree. I just without prejudice, so I see the point.
So there is no question that the person who establishes will like to retain.
I am grateful, Malas. I'm extremely grateful. So this, Malas, takes into account.
That may not flow from the first proposition. Right or establishment itself will not lead to the conclusion that the person who is established or the community which is established is also the
Malas, so may I say it like this? There is no duty to administer, your lordships are right, but there's a right to administer. If I want to administer it through myself, I have a right to do it. But there's no duty that I should administer it only through myself. I can do it like Mr. Sibbal argued through somebody else.
That's a different.
That's the submission.
That's a different argument.
Yes. So Malas, once I have, Malas, so there's a duty and there's no obligation that you must continue to administer through yourself.
You are in fact yourself now accepting establishment may be by one person, administration may be by another person or a community.
Malas, I am only saying this without prejudice to his argument, but I'm just, your lordship will allow me to make the submission just for a moment. Malas, the minute there can be today, what is the legal regime? Malas, without going into the details. Malas, let us assume it's a legal regime which does not aggressively exclude others from participation in the university. That's the point. It doesn't say people who are not Muslims will be limited to 5% or 10% or 15%. Right? That's what. But can that ever be determinative? Once I have established it and I am de facto actually running it, a neutral regime does not impact my de facto administration. A legally neutral regime, the regime which can become problematic, which will infringe my right, will be this. If the parliament tomorrow says that you, Mr. AMU, cannot have more than 20% Muslims in your EC, I'll immediately challenge it. Although I need not, but I will immediately challenge it, saying, listen, I want to administrate through myself, you're violating it. But a neutral regime which doesn't reserve seats for Muslims, till that time I'm in de facto control, does not at all, I'm in administration today, the present regime does not, legal regime, does not in any way impact my day-to-day administration. I'll show that in a moment. In court, in EC, in academic council, Muslims are in overwhelming majority. With the present legal regime, why do I need to challenge it? So a neutral regime, a regime which does not, in a secular country, I am an institution of higher learning. If in a secular country run by a constitution, I have not aggressively sought to limit others, will that be a point against me? Even though factually I'm in complete control and there's no risk of losing that control. On that, just some data. Your lordships will have volume 3C. First, volume 3C, your lordships will have page 551. Page 551 of volume 3C, C for Calcutta. Plus, first is AMU court composition. Plus, this actually 51. This is, because this has been filed by the university itself before your lordships. I'm just taking your lordships through it. From 19, this is the court, the actual composition of the court in terms 551. Yes, lordship. So it has taken all the different appointees, how the people in the court are appointed, different provisions on the left-hand side, and then said from year to year how many Muslims and non-Muslims were there. M and NM is the plus indicator of Muslims and non-Muslims. Plus 1983, your lordships will have at the bottom straight away. Total. I just want to show the total. Plus 165.7. This is the court. This is the supreme body as even Basha recognizes. And this is 81 onwards. 152.7, 152.11, 95.15, 137.15. Because this ends at the latest 223 your lordships will get, 2023, at page 557. At the bottom is total. Again, 2018 is 147, 15, 129, 20, 75, 15. That is still 82%. So, Mullah, at no point in time for the last 40 years, the court has had less than 80% Muslims, de facto control, despite the legal regime, whatever it may have been. Well, why do I need to change the legal regime and aggressively prevent when all my feeding bodies to the court are ensuring that the composition does not change, that the minorities are in control, in fact. And this is, well, I've shown the data for 40 years, but your lordships may take it. This is the status for 104 years, undisputed. Now, my lords, kindly have page 558, which is EC, Executive Council composition. Plus 558, the next page of it's 558, if your lordships will have it. Next page, 558. Well, this is the EC composition from 83 onwards for the last 40 years. At the bottom, your lordships will see M16, NM4, 16.4, 15.4, 22.5, 17.4. 80 to 95% is the range. Your lordships, this ends. Just kindly have 564 for a moment, 563 first for a moment, page 563 at the bottom. In years 2015 and 16, 21-0, 27-0, 27 Muslims know this thing. That's not something to take pride of, but the point I'm saying is that by and large, 80 to 100% EC, which is the primary executive body, is in de facto control of the minority. So court I have shown, Mullahs, executive council I have shown now. And this is with a completely secular regime, which doesn't positively say, oh, so and so has to be limited to 5%. Plus now the academic council, which is the third body. Plus court, EC, AC are the three bodies which run the university. Now the third body, which is the academic council. And that your lordships will find at page 565. Plus at the bottom, Muslims 102, non-Muslims 113. This is 83. Again, Muslims 102, 13, 91, 14. And this ends at 572, the current position. Your lordships will have the current position in 2023. 136.7 as of today. Academic council. And the reason for this is this: the way the EC, AC, etc. are the feeder mechanisms for this are in effect old boys societies, alumni societies, other minority institutions, etc. So it's ensured. So the fact that I positively, aggressively do not discriminate in my statute against others is immaterial. Because with that legal regime, I am ensured a de facto control. There's no threat today with the existing legal regime of losing the de facto control. The thing which will be problematic, like I said, if the parliament says you can't in your EC have more than 20% Muslims, then I'll challenge it. But a secular regime doesn't impact me. And that mixes up secularism and right under Article 30. That actually blends in very well with the scheme of the constitution as to what's the meaning of. I don't need to aggressively remove others in my document to show that, oh, I'm minority. Only if I positively exclude aggressively everybody else. So once I am established, unless I, who have a right to then administer, feel threatened by any provision, I continue to administer the institution also. Your lordships will not just check provisions, therefore, and say, oh, because of this, you are excluded, therefore it's a problem.
You're not aggrieved by therefore, neither the 51 or 65 have been made.
Plus 65, really, 51 people challenged when all Muslim court was changed to a secular provision, really speaking. But Basha itself recognizes that on the ground, nothing changed because of this mechanism.
My question is not that.
Because really speaking, today I'm speaking for the petitioner. I can't, of course, speak for everybody. Speaking for the petitioner I represent, I'm not aggrieved by that. I'm not aggrieved by that. And the present dispute arises, just one detour, present dispute arises in the context of reservations. That's the next data. I'll just quickly put it and then.
That is a separate question altogether.
No, but how does, this has come to your lordships. Why this dispute arose in 2005.
If you're wanting to go into that question, then we'll have to.
No, not just. I'm just flagging something. I'm not at all going to address it on merits. Not at all. Just flagging one point. The present dispute only arises not because of any provisions really in that. What happened, 50% reservation was given, and the only reason to give that was in the professional schools, Jawaharlal Nehru Medical College, a very sought after college. The distribution, for instance, is almost 50-50 between Muslim and non-Muslim. Sometimes it can be 45 also, Muslims go to 45 sometimes. So there the idea was to protect that to 50. Otherwise, in the rest of the university, I have the data here, 70 to 80% student body is Muslim. The need for reservation, that's how the present dispute arises, only in the context of professional, highly competitive spaces, medical and engineering colleges, lordships, no, anywhere is highly competitive. That's the space where there was basically a reservation was brought in. Otherwise, reservation is not even needed because 70 to 80% of the student body is anyways Muslim.
You have St. Stephen's College, you have TMA Pi, Xavier's in between. So don't go on that. If you go on that, we'll have to.
Well, the test in Stephens would have come to my rescue even if I was not in this position. All I'm saying, I don't even need that test necessarily, is my submission to your lordships, given my situation. Of course, if I was worse off, the test would still help me, no doubt. But just if your lordships will permit, one page if I can hand over, if lordships will permit, just the data and then of the composition of the student body.
Stop for them. I will drop. Then we can take.
Whereas the total students today in the university is 23,675. Out of that, the Muslim students are 18,700, which Malas comes to percentage of Muslim students 77.39%. Percentage of Muslim female students out of all the women students, 81% are Muslim. Out of the male students, 79% are Muslim. And the overall composition, 77.39. That's how it comes. So, Malas, the control on the administrative side is substantial. It's catering to the Muslim community in substance. It also takes everybody else in alignment with the secular ethos of the constitution without aggressively discriminating against it. Can that be a point against me, Malas, in a constitutional adjudication? That I cease to be a minority? So, Malas, that's the submission on administration. That's my final submission. Malas, this university has served a very important purpose of creating an educated Muslim middle class. It has literally created, I don't intend to exaggerate, it actually has education of Muslims and AMU go hand in hand. And the reason is the minority status is very relevant for that. Well, this is recognized in many judgments of your lordships as well. I'm not going to take you through them. But the point is this. Students from Bengal, from Karnataka, from Kerala, from Muslim families will send their children only to AMU. They may be today, they may not 100 years back, they may not have been great universities, but today they're exceptional universities all over the country. A Presidency College is there, Calcutta University is there, in South Malad we have. But lot of, that's the composition, I could not place it, but the composition of AMU is from all over India. Because of its minority status, because that minority identity, which I started my submissions with, is relevant to a minority. That's why we have that Article 30. And this is especially true for Malas women students, because the burden of bearing the cultural markers of identity, be it a majority or be it a minority, always comes on the women. And when it comes to girl education, the existence of the minority status of AMU is very relevant. It's a very important consideration in families sending their women to this institution and possibly to access higher education at all. If the institution ceases to be a Muslim minority institution, it may very well hamper the education of Muslim women in India, higher education of Muslim women in India.
But over the last 100 years, without the minority institution tag, it has continued to be an institution of national importance.
Plus, de
How does
facto,
it matter that if we are not with you on Bhasha, you started your address by saying this, then it would create great damage.
plus
Without the minority tag, Institution has continued to be an institution of national importance.
So may I-
How does it matter
Yes.
for the people whether it is a minority institution or not? It's only the brand name, AMU.
Well, may I try to answer that? Because although Basha came, until Basha, it was considered as a minority institution. Basha came. 81 amendments sought to undo it. Thereafter, Malas, this has been litigated through. There has always been a stay, in effect, except on the reservation aspect. The 81 amendment, to the extent it sought to clarify the establishment and therefore the minority status. In my submission, wrongly so, it couldn't have done it, but that doesn't matter. There's always been a stay. So really speaking, today, because of the operation of the status quo orders of your lordships on the 81 amendment, it continues to be a minority institution. In fact, if your lordships uphold Basha, for the first time clearly now, it will become a non-minority institution.
The last argument may have a counterpoint. We're not going into that. There'll be counterpoint.
That's fair enough.
That's a more.
My
of
submission
a-
is this, that a minority.
That may not be a purely a legal argument.
It may not be, because your lordships, when you are interpreting established under Article 30, your lordships will take the social circumstance in some level of account. Of course, it's not a purely legal argument. If something can promote Muslim girl education possibly and ensure the minority status, well, there's no harm in it. In a secular,
Muslim women is, they are studying everywhere. Let's not belittle them. They are studying in every.
because I'm
corner
not
of-
belittling anybody.
Not because of.
It's a fact in the community.
Yes.
It is a fact in the community. Your lordships, I mean, these are sociological aspects. So of course, your lordships will not make a judicial finding on it. But it's a fact that communities send their children generally and women specifically because of the minority status. It's a fact. Well, finally, so what I would submit, just I want to read out three, Mullahs, there is a very illustrious list of women, just want to place, women alumni of AMU. Plus that is there in, if your lordships will have my written submission, para 24, this is volume 2B. Plus page 35, in red, page 35, running page 35. 1B, I'm sorry, 1B, my apologies, 1B. 1B, page 35. In 1924, in 1937, the school was upgraded to AMU Women's College. Notably, the AMU's Women's College was established at a time when the literacy rate among Indian women was just 3%, and almost 2 decades before premier women colleges such as LSR came into existence. In this manner, AMU became a catalyst for empowering Muslim women, breaking societal norms and contributing to the broader movement for women's right and education in India during the early 20th century. The university's commitment to gender equality and educational opportunity laid a foundation for the advancement of women in various fields, contributing to their socio-economic and intellectual upliftment. The success of AMU is therefore inseparable from the triumphs of Muslim women in the subcontinent who have excelled across diverse fields. Among these are trailblazers such as Rana Safvi, a distinguished historian, Ismat Chughtai, your lordships are aware of Lihaf, a renowned novelist, Hashima Hassan, a notable scientist at NASA, and renowned educationist Najma Akhtar. These accomplished women have made significant contribution in areas such as law, education, politics, literature, and activism, underscoring the broad spectrum of talent that AMU has fostered over the years. In fact, even the first chancellor of AMU was a woman, Sultan Jahan Begum of Bhopal. The appointment of a woman as the inaugural chancellor marked a significant historical milestone. It was the first time a woman served as the chancellor of any Indian university. So, Manoj, the point I'm making is the minority status and the women education have gone somewhat together. And it has really fostered Malaz, education amongst Muslims, in particular Muslim women, and that can be impacted potentially. And Malaz, finally, I'll just conclude my submissions with something, Malaz, I saw in the union's written submissions by the learned solicitor. Malaz, the broad width of that submission is that you are such a great institution. You are so good, you are excellent, you have faculties across the board. How could you be minority? No, it's not. I'm paraphrasing it. I'm certainly paraphrasing it. But the point is, it is an institution of national importance. It is an institution of national importance and a big institution. It's an institution of excellence. And somewhat that leads to the fact that you are not a minority. My respectful submission is that AMU does what Article 30 requires of minority institutions exceptionally well. That should not be held against it. The fact that I'm a successful minority institution cannot be the basis for making me move out of that minority zone. So this is on the aspect, also on entry 63, final conclusion. Entry
Mr.
63,
Shamsad.
national importance, institutes of national importance, just on that final submission. A minority institution can be an institution of national importance. There's nothing. It's not as if only the majorities can establish institutes of national importance. Well, that's my final submission. I'm extremely grateful for that.
Thank you, Mr.
Lalit,
Thank you, Mr. Parasar.
Only one question. Is there any other institution, minority institution in the country, which is 100% funded by Government of India?
I cannot perfectly answer that because I don't have the data, but my understanding is that most minority institutions, including Jamia Millia Islamia, for instance,
100%.
was 100%, substantially, nearly 100 it would be, exact numbers I can't, but substantially funded. Even Jamia Millia Islamia in Delhi, which is established under the 87 Act of Parliament, will almost be nearly 100. I can't vouch, of course, exactly 100. I'm grateful.
Your Lordship, whatever time I am left with, Your Lordship may permit me on two aspects. One is how Anjuman Rahmania approached Your Lordship in 1981 and how finally that petition was disposed of. Despite on 26 November 1981, Honorable 2 judges referring the matter to 7 judges. So first, Your Lordship may have the reference. I need to read few lines of that reference because it is important. Your Lordship may have 3A 209, volume 3A 209. I have placed that writ petition also on record, my lord, of 1981. The circumstance due to which that petition came to be filed. 3A 209, if Your Lordship has, at the bottom, Your Lordship has recorded
About 15 minutes or so.
if Your Lordship gives me 15 minutes today, I'll be able to conclude. Otherwise, Your Lordship may give me next day.
So Shamsad, we don't want to rush you. You take your 10 minutes or 15 minutes after we come back. Next week, we are not sitting.
I'm so deeply obliged.
Hmm?
I'm
Then
so
we give
deeply
you-
obliged.
Then now, we'll be sitting on the 23rd for this matter. We'll give you 15 minutes, but keep down.
I'll not exceed 20 minutes, my lord. 15 to 20.
15 now.
I'm so deeply obliged.
There's another time. Rushed by the fact that you are rising, so we'll give you a little time on.
I'm
on the
so
go.
deeply obliged.
सभी को नमस्कार। सबसे पहले तो मैं आपके माध्यम से देश के यशस्वी प्रधानमंत्री नरेंद्र मोदी जी का, राष्ट्रीय अध्यक्ष सम्मानीय जेपी नड्डा जी का, हमारे यशस्वी गृह मंत्री सम्मानीय अमित शाह जी का, हमारे रक्षा मंत्री सम्मानीय राजनाथ सिंह जी का, हमारे केंद्रीय सड़क परिवहन मंत्री सम्मानीय नितिन गडकरी जी का, सभी हमारे राजस्थान के हमारे तीनों केंद्रीय मंत्री माननीय गजेंद्र सिंह जी, अर्जुन मेघवाल जी, कैलाश जी, हमारी प्रदेश की पूर्व मुख्यमंत्री राष्ट्रीय उपाध्यक्ष वसुंधरा जी, प्रदेश अध्यक्ष सीपी जोशी जी और प्रदेशों से आए सभी मुख्यमंत्री, उप मुख्यमंत्री जी जो हमारे इस शपथ ग्रहण समारोह में आए, सभी हमारे आगंतुकों को मैं बहुत बहुत धन्यवाद देता हूं और मेरे परिवारी जन राजस्थान के सभी जो मेरे कार्यकर्ता हैं वो शपथ ग्रहण में शामिल हुए, उन सभी को भी मैं बहुत बहुत धन्यवाद देता हूं और आप सभी को भी मैं बहुत बहुत धन्यवाद देना चाहता हूं कि आपने भी बहुत बड़ा सहयोग करके राजस्थान के एक एक जन जन के कार्यकर्ता और जनता, उन सभी का मैं आभार व्यक्त करता हूं कि इतनी बड़ी संख्या में वो सभी पधारे, उसके लिए मैं उनका भी बहुत बहुत धन्यवाद करता हूं। मित्रों, भारतीय जनता पार्टी राजस्थान ने चुनाव लड़ा, माननीय देश के यशस्वी प्रधानमंत्री नरेंद्र मोदी जी जो गारंटी हमारा घोषणा पत्र है, उस घोषणा पत्र को भी हम पूरी तरह से पालना करते हुए आगे काम करेंगे। मैं उन विषयों को भी धीरे धीरे हम लेना चाहेंगे जिनसे राजस्थान की जनता त्रस्त थी। हम उन विषयों को भी लेना चाहेंगे जिन विषयों को लेकर के देश के यशस्वी प्रधानमंत्री नरेंद्र मोदी जी हमारे पंडित दीनदयाल उपाध्याय जी की अंत्योदय की योजना को लेकर के उस अंतिम व्यक्ति के पायदान के लिए, उस अंतिम व्यक्ति का सहारा बनने के लिए, उस अंतिम व्यक्ति की अभिभूति के लिए देश की यशस्वी प्रधानमंत्री नरेंद्र मोदी जी जो काम कर रहे हैं, उन विषयों को भी हम लेना चाहते हैं। मैं आपके माध्यम से मैं बताना चाहता हूं कि महिलाओं के लिए हमारी यशस्वी प्रधानमंत्री जी ने जिस तरह का काम किया है पूरे देश के अंदर, हमने राजस्थान में महिला और बाल का अत्याचार देखा है। हमारी ये सरकार किसी भी कीमत पर महिला और बाल का अत्याचार सहन नहीं करेगी। महिला सुरक्षा, भ्रष्टाचार हमारी प्रमुख रूप से प्राथमिकताएं रहेंगी। कानून व्यवस्था हमारा प्रमुख विषय रहेगा। महिला सुरक्षा, भ्रष्टाचार उन्मूलन हमारी सरकार की मुख्य प्राथमिकताएं होंगी। देश के यशस्वी प्रधानमंत्री श्री नरेंद्र मोदी जी के नेतृत्व में मार्गदर्शन में चलते हुए प्रदेश की डबल इंजन की सरकार किसान, गरीब, महिलाओं, युवाओं को ध्यान में रखते हुए मजबूत फैसले लेंगे। महिलाओं के विरुद्ध अपराध पर किया जाएगा पूर्ण नियंत्रण, जिम्मेदारी भी दी जाएगी। महिलाओं के विरुद्ध अपराधों के समूल उन्मूलन के लिए हमारी सरकार कृत संकल्पित है। असामाजिक एवं आपराधिक तत्वों को चिन्हित कर उन पर भी कठोर कार्रवाई की जाएगी। प्रदेश की जनता को मिलेगी भ्रष्टाचार से मुक्ति। सरकार भ्रष्टाचार के विरुद्ध जीरो टॉलरेंस की नीति पर चलते हुए कार्य करेगी। लंबित प्रकरण को तुरंत निस्तारण होगा। विभिन्न कार्यालयों में आने वाले प्रत्येक व्यक्ति की समस्या का संवेदनशीलता से एवं सम्मान के साथ समाधान किया जाएगा। भ्रष्टाचार की जवाबदेही भी तय की जाएगी। पेपर लीक मामले की जांच के लिए एसआईटी का गठन किया जाएगा। बृहद स्तर पर पेपर लीक की घटना सामने आई है। इसमें प्रदेश के युवाओं को मनोबल टूटा है। आज ही हमने एसआईटी का गठन की प्रक्रिया प्रारंभ की और आज मैं कहना चाहता हूं कि एसआईटी का गठन होगा। पेपर लीक के मामले में के लिए जांच एसआईटी गठन करने का निर्णय लिया है। प्रदेश के युवाओं की शक्ति के भविष्य के साथ जो खिलवाड़ करने वाले अपराधियों को सख्त सजा मिलेगी, क्योंकि उन युवाओं का भविष्य अंधकार में जिन्होंने डालने का काम किया है, ये सरकार किसी कीमत पर उनको बख्शने वाली नहीं है। भविष्य में कोई पेपर लीक की घटना ना हो, ये सुनिश्चित किया जाएगा। जिन्होंने किया है उनको छोड़ा नहीं जाएगा। एंटी गैंगस्टर टास्क फोर्स की भी घोषणा करते हैं। संगठित अपराध उन्मूलन के लिए एडीजीपी अधिकारी के नेतृत्व में एक विशेष कार्यदल एंटी गैंगस्टर टास्क फोर्स का गठन किया जाएगा। प्रदेश के अंदर किसी भी तरह का अपराध नहीं होने दिया जाएगा। सख्त कार्रवाई की जाएगी और किसी भी तरह का अपराध होगा उसके खिलाफ कार्रवाई होगी। जैसा मैंने कहा, देश के यशस्वी प्रधानमंत्री नरेंद्र मोदी जी पंडित दीनदयाल उपाध्याय जी के अंत्योदय की योजना को लेकर के कल 16 दिसंबर को पूरे राजस्थान के अंदर विकसित भारत संकल्प यात्रा से जनता तक पहुंचेगी जन कल्याणकारी योजना है। मैं आपके माध्यम से मैं बताना चाहता हूं कि माननीय प्रधानमंत्री जी का ये ड्रीम प्रोजेक्ट पंडित दीनदयाल उपाध्याय के अंत्योदय को लेकर के जो उन्होंने पूरे देश के अंदर उन गरीब परिवारों को चिन्हित करने का भी काम किया है और उनको उन योजनाओं का लाभ देने का भी काम किया है। हम चाहते हैं कि कोई भी पात्र व्यक्ति इस योजनाओं से वंचित ना रहे। इसके लिए भी हमने एक प्रदेश के अंदर एक मॉनिटरिंग कमेटी का गठन किया है कि प्रतिदिन कितने पात्र लोगों को लाभ देने का काम किया है। ये काम सिर्फ पेपर पर नहीं होगा, ये काम जनता के बीच में जाकर के जो हमारा विकसित भारत संकल्प यात्रा है, इसके माध्यम से पूरे प्रदेश के अंदर होगा। देश के यशस्वी प्रधानमंत्री श्री नरेंद्र मोदी के विजन पर चलते हुए भारत विकासशील से विकसित देश बनने की ओर तेजी से अग्रसर हो रहा है। यात्रा के तहत प्रदेश में सभी लाभार्थियों तक जन कल्याणकारी योजनाओं की पहुंच सुनिश्चितता की जाएगी। सभी पात्र व्यक्तियों को योजनाओं से जोड़कर उनके जीवन स्तर को ऊपर उठाकर उनके सशक्तिकरण का कार्य करेगी। यात्रा के द्वारा अब तक सरकारी योजनाओं के लाभ से वंचित सभी प्रदेशवासियों को लाभान्वित किया जाएगा। किसी भी प्रकार से अगर कोई पात्र व्यक्ति छूटता है तो इसकी जिम्मेदारी भी तय की जाएगी कि वो पात्र व्यक्ति किस कारण से छूटा गया। मैं आपके माध्यम से इतना निवेदन करना चाहता हूं, ये हमारी सरकार अंत्योदय गरीब कल्याण के लिए उस अंतिम पायदान पर बैठे उस व्यक्ति के लिए जिसको आवश्यकता है, उस आवश्यकता की पूर्ति के लिए और उस पात्र व्यक्ति को उसका पूर्ण रूप से विकास की माननीय नरेंद्र मोदी जी की योजनाओं का लाभ मिले, ये सुनिश्चितता हमारी सरकार करेगी। मैं आपको आज इतना ही, समय समय पर आगे और भी हमारे जो काम है उनके बारे में आपको जानकारी दी जाएगी। आपके माध्यम से मैं इतना ही, सभी को नमस्कार, जय हिंद, जय भारत। अगले दिन आपके माध्यम से देश के यशस्वी प्रधानमंत्री नरेंद्र मोदी जी का, राष्ट्रीय अध्यक्ष सम्मानीय JP नड्डा जी का, हमारे यशस्वी गृह मंत्री सम्मानीय अमित शाह जी का, हमारे रक्षा मंत्री सम्मानीय राजनाथ सिंह जी का, हमारे केंद्रीय सड़क परिवहन मंत्री सम्मानीय नितिन गडकरी जी का, सभी हमारे राजस्थान के हमारे तीनों केंद्रीय मंत्री माननीय गजेंद्र सिंह जी, अर्जुन मेघवाल जी, कैलाश जी, हमारी प्रदेश की पूर्व मुख्यमंत्री राष्ट्रीय उपाध्यक्ष वसुंधरा जी, प्रदेश अध्यक्ष CP जोशी जी और प्रदेशों से आए सभी मुख्यमंत्री, उप मुख्यमंत्री जी जो हमारे इस शपथ ग्रहण समारोह में आए, सभी हमारे आगंतुकों को मैं बहुत बहुत धन्यवाद देता हूं। और मेरे परिवारी जन राजस्थान के सभी जो मेरे कार्यकर्ता हैं, वो शपथ ग्रहण में शामिल हुए, उन सभी को भी मैं बहुत बहुत धन्यवाद देता हूं। और आप सभी को भी मैं बहुत बहुत धन्यवाद देना चाहता हूं कि आपने भी बहुत बड़ा सहयोग करके राजस्थान के एक एक जन जन के कार्यकर्ता और जनता, उन सभी का मैं आभार व्यक्त करता हूं कि इतनी बड़ी संख्या में वो सभी पधारे, उसके लिए मैं उनका भी बहुत बहुत धन्यवाद करता हूं। मित्रों, भारतीय जनता पार्टी राजस्थान ने चुनाव लड़ा, माननीय देश के यशस्वी प्रधानमंत्री नरेंद्र मोदी जी जो गारंटी हमारा घोषणा पत्र है, उस घोषणा पत्र को भी हम पूरी तरह से पालना करते हुए आगे काम करेंगे। मैं उन विषयों को भी धीरे धीरे हम लेना चाहेंगे जिनसे राजस्थान की जनता त्रस्त थी। हम उन विषयों को भी लेना चाहेंगे जिन विषयों को लेकर के देश के यशस्वी प्रधानमंत्री नरेंद्र मोदी जी हमारे पंडित दीनदयाल उपाध्याय जी की अंत्योदय की योजना को लेकर के उस अंतिम व्यक्ति के पायदान के लिए, उस अंतिम व्यक्ति का सहारा बनने के लिए, उस अंतिम व्यक्ति की अभिभूति के लिए देश के यशस्वी प्रधानमंत्री नरेंद्र मोदी जी जो काम कर रहे हैं, उन विषयों को भी हम लेना चाहते हैं। मैं आपके माध्यम से मैं बताना चाहता हूं कि महिलाओं के लिए हमारे यशस्वी प्रधानमंत्री जी ने जिस तरह का काम किया है पूरे देश के अंदर, हमने राजस्थान में महिला और बाल का अत्याचार देखा है। हमारी ये सरकार किसी भी कीमत पर महिला और बाल का अत्याचार सहन नहीं करेगी। महिला सुरक्षा, भ्रष्टाचार हमारी प्रमुख रूप से प्राथमिकताएं रहेंगी। कानून व्यवस्था हमारा प्रमुख विषय रहेगा। महिला सुरक्षा, भ्रष्टाचार उन्मूलन हमारी सरकार की मुख्य प्राथमिकताएं होंगी। देश के यशस्वी प्रधानमंत्री श्री नरेंद्र मोदी के नेतृत्व में मार्गदर्शन में चलते हुए प्रदेश की डबल इंजन की सरकार किसान, गरीब, महिलाओं, युवाओं को ध्यान में रखते हुए मजबूत फैसले लेंगे। महिलाओं के विरुद्ध अपराध पर किया जाएगा पूर्ण नियंत्रण, जिम्मेदारी भी दी जाएगी। महिलाओं के विरुद्ध अपराधों के समूल उन्मूलन के लिए हमारी सरकार कृत संकल्पित है। असामाजिक एवं आपराधिक तत्वों को चिन्हित कर उन पर भी कठोर कार्रवाई की जाएगी। प्रदेश की जनता को मिलेगी भ्रष्टाचार से मुक्ति। सरकार भ्रष्टाचार के विरुद्ध जीरो टॉलरेंस की नीति पर चलते हुए कार्य करेगी। लंबित प्रकरण को तुरंत निस्तारण होगा। विभिन्न कार्यालयों में आने वाले प्रत्येक व्यक्ति की समस्या का संवेदनशीलता से एवं सम्मान के साथ समाधान किया जाएगा। भ्रष्टाचार की जवाबदेही भी तय की जाएगी। पेपर लीक मामले की जांच के लिए एसआईटी का गठन किया जाएगा। वृहद स्तर पर पेपर लीक की घटना सामने आई हैं। इसमें प्रदेश के युवाओं को मनोबल टूटा है। आज ही हमने एसआईटी का गठन की प्रक्रिया प्रारंभ की और आज मैं कहना चाहता हूं कि एसआईटी का गठन होगा। पेपर लीक के मामले में के लिए जांच एसआईटी की गठन करने का निर्णय लिया है। प्रदेश के युवाओं की शक्ति के भविष्य के साथ जो खिलवाड़ करने वाले अपराधियों को सख्त सजा मिलेगी, क्योंकि उन युवाओं का भविष्य अंधकार में जिन्होंने डालने का काम किया है, ये सरकार किसी कीमत पर उनको बख्शने वाली नहीं है। भविष्य में कोई पेपर लीक की घटना ना हो, ये सुनिश्चित किया जाएगा। जिन्होंने किया है उनको छोड़ा नहीं जाएगा। एंटी गैंगस्टर टास्क फोर्स की भी घोषणा करते हैं। संगठित अपराध उन्मूलन के लिए एडीजीपी अधिकारी के नेतृत्व में एक विशेष कार्यदल एंटी गैंगस्टर टास्क फोर्स का गठन किया जाएगा। प्रदेश के अंदर किसी भी तरह का अपराध नहीं होने दिया जाएगा। सख्त कार्रवाई की जाएगी और किसी भी तरह का अपराध होगा उसके खिलाफ कार्रवाई होगी। जैसा मैंने कहा, देश के यशस्वी प्रधानमंत्री नरेंद्र मोदी जी पंडित दीनदयाल उपाध्याय जी के अंत्योदय की योजना को लेकर के कल 16 दिसंबर को पूरे राजस्थान के अंदर विकसित भारत संकल्प यात्रा से जनता तक पहुंचेगी जन कल्याणकारी योजना है। मैं आपके माध्यम से मैं बताना चाहता हूं कि माननीय प्रधानमंत्री जी का ये ड्रीम प्रोजेक्ट पंडित दीनदयाल उपाध्याय के अंत्योदय को लेकर के जो उन्होंने पूरे देश के अंदर उन गरीब परिवारों को चिन्हित करने का भी काम किया है और उनको उन योजनाओं का लाभ देने का भी काम किया है। हम चाहते हैं कि कोई भी पात्र व्यक्ति इस योजनाओं से वंचित ना रहे। इसके लिए भी हमने एक प्रदेश के अंदर एक मॉनिटरिंग कमेटी का गठन किया है कि प्रतिदिन कितने पात्र लोगों को लाभ देने का काम किया है। ये काम सिर्फ पेपर पर नहीं होगा, ये काम जनता के बीच में जाकर के जो हमारा विकसित भारत संकल्प यात्रा है, इसके माध्यम से पूरे प्रदेश के अंदर होगा। देश के यशस्वी प्रधानमंत्री श्री नरेंद्र मोदी के विजन पर चलते हुए भारत विकासशील से विकसित देश बनने की ओर तेजी से अग्रसर हो रहा है। यात्रा के तहत प्रदेश में सभी लाभार्थियों तक जन कल्याणकारी योजनाओं की पहुंच सुनिश्चितता की जाएगी। सभी पात्र व्यक्तियों को योजनाओं से जोड़कर उनके जीवन स्तर को ऊपर उठाकर उनके सशक्तिकरण का कार्य करेगी। यात्रा के द्वारा अब तक सरकारी योजनाओं के लाभ से वंचित सभी प्रदेशवासियों को लाभान्वित किया जाएगा। किसी भी प्रकार से अगर कोई पात्र व्यक्ति छूटता है तो इसकी जिम्मेदारी भी तय की जाएगी कि वो पात्र व्यक्ति किस कारण से छूटा गया। मैं आपके माध्यम से इतना निवेदन करना चाहता हूं, ये हमारी सरकार अंत्योदय गरीब कल्याण के लिए उस अंतिम पायदान पर बैठे उस व्यक्ति के लिए जिसको आवश्यकता है, उस आवश्यकता की पूर्ति के लिए और उस पात्र व्यक्ति को उसका पूर्ण रूप से विकास की माननीय नरेंद्र मोदी जी की योजनाओं का लाभ मिले, ये सुनिश्चितता हमारी सरकार करेगी। मैं आपको आज इतना ही, समय समय पर आगे और भी हमारे जो काम है उनके बारे में आपको जानकारी दी जाएगी। आपके माध्यम से मैं इतना ही, सभी को नमस्कार, जय हिंद, जय भारत। आपके माध्यम से देश के यशस्वी प्रधानमंत्री नरेंद्र मोदी जी का, राष्ट्रीय अध्यक्ष सम्मानीय जेपी नड्डा जी का, हमारे यशस्वी गृह मंत्री सम्मानीय अमित शाह जी का, हमारे रक्षा मंत्री सम्मानीय राजनाथ सिंह जी का, हमारे केंद्रीय सड़क परिवहन मंत्री सम्मानीय नितिन गडकरी जी का, सभी हमारे राजस्थान के हमारे तीनों केंद्रीय मंत्री माननीय गजेंद्र सिंह जी, अर्जुन मेघवाल जी, कैलाश जी, हमारी प्रदेश की पूर्व मुख्यमंत्री राष्ट्रीय उपाध्यक्ष वसुंधरा जी, प्रदेश अध्यक्ष सीपी जोशी जी और प्रदेशों से आए सभी मुख्यमंत्री, उप मुख्यमंत्री जी जो हमारे इस शपथ ग्रहण समारोह में आए, सभी हमारे आगंतुकों को मैं बहुत बहुत धन्यवाद देता हूं और मेरे परिवारीजन राजस्थान के सभी जो मेरे कार्यकर्ता हैं वो शपथ ग्रहण में शामिल हुए, उन सभी को भी मैं बहुत बहुत धन्यवाद देता हूं और आप सभी को भी मैं बहुत बहुत धन्यवाद देना चाहता हूं कि आपने भी बहुत बड़ा सहयोग करके राजस्थान के एक एक जन जन के कार्यकर्ता और जनता, उन सभी का मैं आभार व्यक्त करता हूं कि इतनी बड़ी संख्या में वो सभी पधारे, उसके लिए मैं उनका भी बहुत बहुत धन्यवाद करता हूं। मित्रों, भारतीय जनता पार्टी राजस्थान ने चुनाव लड़ा। माननीय देश के यशस्वी प्रधानमंत्री नरेंद्र मोदी जी जो गारंटी हमारा घोषणा पत्र है, उस घोषणा पत्र को भी हम पूरी तरह से पालना करते हुए आगे काम करेंगे। मैं उन विषयों को भी धीरे धीरे हम लेना चाहेंगे जिनसे राजस्थान की जनता त्रस्त थी। हम उन विषयों को भी लेना चाहेंगे जिन विषयों को लेकर के देश के यशस्वी प्रधानमंत्री नरेंद्र मोदी जी हमारे पंडित दीनदयाल उपाध्याय जी की अंत्योदय की योजना को लेकर के उस अंतिम व्यक्ति के पायदान के लिए, उस अंतिम व्यक्ति का सहारा बनने के लिए, उस अंतिम व्यक्ति की अभिभूति के लिए देश की यशस्वी प्रधानमंत्री नरेंद्र मोदी जी जो काम कर रहे हैं, उन विषयों को भी हम लेना चाहते हैं। मैं आपके माध्यम से मैं बताना चाहता हूं कि महिलाओं के लिए हमारे यशस्वी प्रधानमंत्री जी ने जिस तरह का काम किया है पूरे देश के अंदर, हमने राजस्थान में महिला और बाल का अत्याचार देखा है। हमारी ये सरकार किसी भी कीमत पर महिला और बाल का अत्याचार सहन नहीं करेगी। महिला सुरक्षा, भ्रष्टाचार हमारी प्रमुख रूप से प्राथमिकताएं रहेंगी। कानून व्यवस्था हमारा प्रमुख विषय रहेगा। महिला सुरक्षा, भ्रष्टाचार उन्मूलन हमारी सरकार की मुख्य प्राथमिकताएं होंगी। देश के यशस्वी प्रधानमंत्री श्री नरेंद्र मोदी के नेतृत्व में मार्गदर्शन में चलते हुए प्रदेश की डबल इंजन की सरकार किसान, गरीब, महिलाओं, युवाओं को ध्यान में रखते हुए मजबूत फैसले लेंगे। महिलाओं के विरुद्ध अपराध पर किया जाएगा पूर्ण नियंत्रण, जिम्मेदारी भी दी जाएगी। महिलाओं के विरुद्ध अपराधों के समूल उन्मूलन के लिए हमारी सरकार कृत संकल्पित है। असामाजिक एवं आपराधिक तत्वों को चिन्हित कर उन पर भी कठोर कार्रवाई की जाएगी। प्रदेश की जनता को मिलेगी भ्रष्टाचार से मुक्ति। सरकार भ्रष्टाचार के विरुद्ध जीरो टॉलरेंस की नीति पर चलते हुए कार्य करेगी। लंबित प्रकरण को तुरंत निस्तारण होगा। विभिन्न कार्यालयों में आने वाले प्रत्येक व्यक्ति की समस्या का संवेदनशीलता से एवं सम्मान के साथ समाधान किया जाएगा। भ्रष्टाचार की जवाबदेही भी तय की जाएगी। पेपर लीक मामले की जांच के लिए एसआईटी का गठन किया जाएगा। वृहद स्तर पर पेपर लीक की घटना सामने आई हैं। इसमें प्रदेश के युवाओं को मनोबल टूटा है। आज ही हमने एसआईटी का गठन की प्रक्रिया प्रारंभ की और आज मैं कहना चाहता हूं कि एसआईटी का गठन होगा। पेपर लीक के मामले में के लिए जांच एसआईटी की गठन करने का निर्णय लिया है। प्रदेश के युवाओं की शक्ति के भविष्य के साथ जो खिलवाड़ करने वाले अपराधियों को सख्त सजा मिलेगी, क्योंकि उन युवाओं का भविष्य अंधकार में जिन्होंने डालने का काम किया है, ये सरकार किसी कीमत पर उनको बख्शने वाली नहीं है। भविष्य में कोई पेपर लीक की घटना ना हो, ये सुनिश्चित किया जाएगा। जिन्होंने किया है उनको छोड़ा नहीं जाएगा। एंटी गैंगस्टर टास्क फोर्स की भी घोषणा करते हैं। संगठित अपराध उन्मूलन के लिए एडीजीपी अधिकारी के नेतृत्व में एक विशेष कार्यदल एंटी गैंगस्टर टास्क फोर्स का गठन किया जाएगा। प्रदेश के अंदर किसी भी तरह का अपराध नहीं होने दिया जाएगा। सख्त कार्रवाई की जाएगी और किसी भी तरह का अपराध होगा उसके खिलाफ कार्रवाई होगी। जैसा मैंने कहा, देश के यशस्वी प्रधानमंत्री नरेंद्र मोदी जी पंडित दीनदयाल उपाध्याय जी के अंत्योदय की योजना को लेकर के कल 16 दिसंबर को पूरे राजस्थान के अंदर विकसित भारत संकल्प यात्रा से जनता तक पहुंचेगी जन कल्याणकारी योजना है। मैं आपके माध्यम से मैं बताना चाहता हूं कि माननीय प्रधानमंत्री जी का ये ड्रीम प्रोजेक्ट पंडित दीनदयाल उपाध्याय के अंत्योदय को लेकर के जो उन्होंने पूरे देश के अंदर उन गरीब परिवारों को चिन्हित करने का भी काम किया है और उनको उन योजनाओं का लाभ देने का भी काम किया है। हम चाहते हैं कि कोई भी पात्र व्यक्ति इस योजनाओं से वंचित ना रहे। इसके लिए भी हमने एक प्रदेश के अंदर एक मॉनिटरिंग कमेटी का गठन किया है कि प्रतिदिन कितने पात्र लोगों को लाभ देने का काम किया है। ये काम सिर्फ पेपर पर नहीं होगा, ये काम जनता के बीच में जाकर के जो हमारा विकसित भारत संकल्प यात्रा है इसके माध्यम से पूरे प्रदेश के अंदर होगा। देश के यशस्वी प्रधानमंत्री श्री नरेंद्र मोदी के विजन पर चलते हुए भारत विकासशील से विकसित देश बनने की ओर तेजी से अग्रसर हो रहा है। यात्रा के तहत प्रदेश में सभी लाभार्थियों तक जन कल्याणकारी योजनाओं की पहुंच सुनिश्चितता की जाएगी। सभी पात्र व्यक्तियों को योजनाओं से जोड़कर उनके जीवन स्तर को ऊपर उठाकर उनके सशक्तिकरण का कार्य करेगी। यात्रा के द्वारा अब तक सरकारी योजनाओं के लाभ से वंचित सभी प्रदेशवासियों को लाभान्वित किया जाएगा। किसी भी प्रकार से अगर कोई पात्र व्यक्ति छूटता है तो इसकी जिम्मेदारी भी तय की जाएगी कि वो पात्र व्यक्ति किस कारण से छूटा गया। मैं आपके माध्यम से इतना निवेदन करना चाहता हूं, ये हमारी सरकार अंत्योदय गरीब कल्याण के लिए उस अंतिम पायदान पर बैठे उस व्यक्ति के लिए जिसको आवश्यकता है, उस आवश्यकता की पूर्ति के लिए और उस पात्र व्यक्ति को उसका पूर्ण रूप से विकास की माननीय नरेंद्र मोदी जी की योजनाओं का लाभ मिले, ये सुनिश्चितता हमारी सरकार करेगी। मैं आपको आज इतना ही, समय समय पर आगे और भी हमारे जो काम है उनके बारे में आपको जानकारी दी जाएगी। आपके माध्यम से मैं इतना ही, सभी को नमस्कार, जय हिंद, जय भारत। आपके माध्यम से देश के यशस्वी प्रधानमंत्री नरेंद्र मोदी जी का, राष्ट्रीय अध्यक्ष सम्मानीय जेपी नड्डा जी का, हमारे यशस्वी गृह मंत्री सम्मानीय अमित शाह जी का, हमारे रक्षा मंत्री सम्मानीय राजनाथ सिंह जी का, हमारे केंद्रीय सड़क परिवहन मंत्री सम्मानीय नितिन गडकरी जी का, सभी हमारे राजस्थान के हमारे तीनों केंद्रीय मंत्री माननीय गजेंद्र सिंह जी, अर्जुन मेघवाल जी, कैलाश जी, हमारी प्रदेश की पूर्व मुख्यमंत्री राष्ट्रीय उपाध्यक्ष वसुंधरा जी, प्रदेश अध्यक्ष सीपी जोशी जी और प्रदेशों से आए सभी मुख्यमंत्री, उप मुख्यमंत्री जी जो हमारे इस शपथ ग्रहण समारोह में आए, सभी हमारे आगंतुकों को मैं बहुत बहुत धन्यवाद देता हूं और मेरे परिवारी जन राजस्थान के सभी जो मेरे कार्यकर्ता हैं वो शपथ ग्रहण में शामिल हुए उन सभी को भी मैं बहुत बहुत धन्यवाद देता हूं और आप सभी को भी मैं बहुत बहुत धन्यवाद देना चाहता हूं कि आपने भी बहुत बड़ा सहयोग करके राजस्थान के एक एक जन जन के कार्यकर्ता और जनता उन सभी का मैं आभार व्यक्त करता हूं कि इतनी बड़ी संख्या में वो सभी पधारे, उसके लिए मैं उनका भी बहुत बहुत धन्यवाद करता हूं। मित्रों, भारतीय जनता पार्टी राजस्थान ने चुनाव लड़ा। माननीय देश के यशस्वी प्रधानमंत्री नरेंद्र मोदी जी जो गारंटी हमारा घोषणा पत्र है, उस घोषणा पत्र को भी हम पूरी तरह से पालना करते हुए आगे काम करेंगे। मैं उन विषयों को भी धीरे धीरे हम लेना चाहेंगे जिनसे राजस्थान की जनता त्रस्त थी। हम उन विषयों को भी लेना चाहेंगे जिन विषयों को लेकर के देश के यशस्वी प्रधानमंत्री नरेंद्र मोदी जी हमारे पंडित दीनदयाल उपाध्याय जी की अंत्योदय की योजना को लेकर के उस अंतिम व्यक्ति के पायदान के लिए, उस अंतिम व्यक्ति का सहारा बनने के लिए, उस अंतिम व्यक्ति की अभिभूति के लिए देश की यशस्वी प्रधानमंत्री नरेंद्र मोदी जी जो काम कर रहे हैं, उन विषयों को भी हम लेना चाहते हैं। मैं आपके माध्यम से मैं बताना चाहता हूं कि महिलाओं के लिए हमारे यशस्वी प्रधानमंत्री जी ने जिस तरह का काम किया है पूरे देश के अंदर, हमने राजस्थान में महिला और बाल का अत्याचार देखा है। हमारी ये सरकार किसी भी कीमत पर महिला और बाल का अत्याचार सहन नहीं कर